5 seconds to go. Start. In case of resumption of land by Union government and the same is utilized for construction of barracks, the resumption order is never assailed by grantee, then the possession of that extent of land cannot be taken away from Union of India for delivery to decree holders. Land measuring 3.563 acres situated in survey number 116 within Agra cantonment was held in occupancy rights by one Hamid Ali Khan on the strength of a grant under the Government of India. The grantee, it appears, had constructed what has been described in the order passed by the courts below as bungalow number 194 situated in the cantonment area at Agra pursuant to an application filed jointly by Hamid Ali Khan and Lala Chhel Bihari, the military estates officer, granted permission for transfer of the bungalow aforementioned and the land under and appurtenant thereto in terms of letter dated 3rd August 1946. A sale deed was accordingly executed in respect of the property on 11 September 1946 by Hamid Ali Khan in favor of Chhel Bihari Lal and his two brothers Nawal Kishore and Kapoor Chand. The bungalow in question had been let out by the original grantee to the military estates officer in June 1942 on monthly rental of rupees 125. The purchasers, on the basis of the sale in their favor, acquittal the right to claim the rent payable for the same from the military estates officer. Suit number OS 842 of 1958 was accordingly filed by the purchasers for recovery of arrears of rent and damage and for vacant possession, which suit was decreed for a sum of rupees 1600 only towards rent and damages. The court held that in the absence of any material to show that the government had issued any notice for resumption of the land appertinent to the bungalow, the Government of India was liable to pay damages for remaining in occupation of the barracks which had been built in the compound of bungalow. The grant holder Nawal Kishore and others filed a second suit bearing suit number 6 of 1963 for recovery of rent and damages for use and occupation of the bungalow apparently for the period subsequent to the earlier suit. This suit was also decreed by the trial court. The appeal preferred by the Union of India was, however, allowed, holding that there was no valid contract between the parties in respect of the bungalow and consequently the claim for rent could not be decreed. The claim for payment for damages also failed on account of non compliance with 6 provisions of section 80 of the CPC. A third suit, bearing suit number 99 of 1968, was then filed by the Nawal Kishore and others for recovery of rupees 7800 as arrears of rent and damages with a prayer for possession by eviction of garrison engineer from the main bungalow and the land over which the Government of India had built the barrack. This suit was decreed on 25th October 1969, but only to the extent of recovery of rupees 8977.50 towards rent. The trial court did not go into the question of title to the property as the suit was based on a tenancy in favor of the respondents Union of India. Two appeals came to be filed against the said judgment and decree. While appeal number 294 of 1969 was filed by Nawal Kishore, appeal number 66 of 1970 was filed by the Union of India. Both these appeals were heard together and by a common order. The appeal filed by the Union of India was dismissed, while that filed by the Naval Kishore and others was allowed. The High Court held that although no contractual tenancy came into existence between the parties, a statutory tenancy came into existence under the provisions of the Cantonment House Accommodation Act 1993, and that any such tenancy was not dependent upon the execution of a formal decree. The provisions of Article 299(1) of the Constitution were held to be inapplicable to such tenancy. The High Court also found the composite notice served upon the Union of India under Section 80 CPC and Section 106 of the Transfer of Property Act to be valid and decreed the suit for recovery of possession by ejectment of defendants from the bungalow and the land underlying the same with a direction to remove the barracks that were constructed on a part of the compound, failing which the same were directed to be removed under the orders of the court and the possession delivered to the decree holder. Stop.